Article 6, Section 2 of the U.S. Constitution contains the Supremacy Clause, which says, quote, "This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land." There is nothing in the clause about U.S. Supreme Court opinions. However, in 1958, in a decision called Cooper v. Aaron, the Supreme Court created the doctrine of judicial supremacy. It said, quoting from the opinion, "The interpretation of the 14th Amendment enunciated by this court is the supreme law of the land, and Article 6 of the Constitution makes it binding on the states." End quote. In other words, judicial supremacy is a belief that the U.S. Supreme Court no longer just decides how to interpret and apply the Constitution for the purpose of entering a judgment that resolves a controversy between parties to a lawsuit, but its analysis is now equal to the Constitution and becomes the supreme law for the whole nation. The attorneys who believe in judicial supremacy take it to mean that a Supreme Court judgment against one state's law, say Ohio's, has the legal effect of prohibiting officials in another state, say Tennessee, from continuing to enforce a similar law in their state, even if, for example, Tennessee might have made a different or better argument in defense of its law than Ohio did, or one that perhaps the Supreme Court didn't even consider in the Ohio case. And some politicians believe that judicial supremacy means even that if Tennessee's laws on abortion or marriage or any other subject were distinguishable from, say, Ohio's, well, Tennessee just should not spend the time and the money defending its laws by trying to distinguish them from the ones in Ohio or making a different argument in defense of Tennessee's laws. On the other hand, other attorneys, including those at FACT, do not embrace the doctrine of judicial supremacy because Article 3 of the U.S. Constitution limits the jurisdiction of federal courts to deciding only cases and controversies. These attorneys believe the Supreme Court cannot enter a legally binding judgment against a state that was not a party to a particular lawsuit in which a judgment was rendered. They believe the Supreme Court only resolves disputes between parties. They enter judgments that do not make law for the whole nation. Would you agree with FACT that the doctrine of judicial supremacy gives federal courts powers they do not have under the U.S. Constitution and makes the Supreme Court supreme over the Constitution itself?